The Brown v. Board of Education case was brought to the Supreme Court in 1953. It was a collection of 5 separate cases. While the facts of each case are different, the main issue in each was the constitutionality of state-sponsored segregation in public schools. Thurgood Marshall and the National Association for the Advancement of Colored People Legal Defense and Education Fund handled these cases. Marshall personally argued the case before the court. Although he raised a variety of legal issues on appeal, the most common one was that separate school systems for blacks and whites were inherently unequal and thus violate the Equal Protection Clause of the 14th Amendment.
History lessons. Real quick, the 14th Amendment is all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and the state wherein they reside. No state shall make or enforce any laws, this is important, which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or poverty without due process of the law, nor deny any person within its jurisdiction the equal protection of the laws.
He also argued that segregated school systems had a tendency to make black children feel inferior to white children, and thus a system should not be legally permissible.
This is a quick history on the events that led up to the court case of Brown versus the Board of Education. In 1887, the Jim Crow laws were introduced, which practiced comprehensive racial segregation. Florida was the first state to require public segregation, and then was followed by 8 other states. In 1896, the Supreme Court held separate but equal facilities for white and black railroad passengers did not violate the Equal Protection Clause of the 14th Amendment. They introduced separate but equal, which served as a basis for segregation. 1909, the NAACP, or the National Association for the Advancement of Colored People, was founded. 1935, the NAACP began challenging segregation in graduate and secondary schools.
Linda Brown, who as a schoolgirl was at the center of the U.S. Supreme Court landmark case that rejected racial segregation in American schools. The 1954 Supreme Court case, Brown versus the Board of Education, involved several families, all trying to dismantle decades of federal education laws that condone segregated schools for black and white students. But it began with Brown's father, Oliver, who tried to enroll her at the Sumner School, an all-white elementary school in Topeka, just a few blocks from the Brown's house.
The school board prohibited the child from enrolling, and Brown, an assistant pastor at a church, was angry that his daughter had to be shuttled miles away to go to school.
She had to endure so many things just to get to school. It wasn't fair, because she just wanted to go to school. So she had to walk several miles away. She had to endure the cold during the winter time, which was really difficult for her to get to school. And she had to endure all this pain. And her father was really mad at it because it feels like she's really young and she has the right to go to school. Why she can go to school with the other kids? The school is really close to the place. Why she had to walk several miles away to get to just to go to school? It just doesn't make sense. So her dad had to take it to the court and fight for her right to go to school, her right to go to the school which her friends attend.
Please enjoy our historical and very accurate representation of what Linda Brown had to go through just to go to school.
Anifi.
Linda, I'm sorry to inform you, but instead of going to the school that's right by our house, you're gonna have to walk several miles just to go to school.
Why, Dad?
Well, Linda, it's because we're different.
How are we different, Dad?
Well, the people look at us different.
But I just want to go to school.
God damn it, Linda! It's because we're colored! Okay? Go to school!
Alright, Dad. Why do I have to do this every day? Why can't I be with the other kids?
Linda, why would you do that? This is awful. Why would they do such a thing? This is unconstitutional. We need to end segregation. There's no reason my daughter should not go to the school by her house. It's so much safer. When she goes to the all.
The justices of the Supreme Court were deeply divided over the issues raised.
Segregation of public schools is a direct infringement on the 14th Amendment right.
Separate but equal is a law, and it gives the same funding to all the schools.
But even though if the schools are equal, but there's still a feeling of inferiority between the students.
But they're still equal.
Unable to come up with a solution by June in 1953, the court decided to rehear the case in December 1953. During the intervening months, however, the Chief Justice died and was replaced by Governor Earl Warren of California. After the case was reheard in 1953, Chief Justice Warren was able to get all the justices to agree to support a unanimous decision declaring segregation in public schools unconstitutional.
According to the 14th Amendment right, it states, ask my secretary here, no state shall make or enforce any law that which shall abridge the privileges of immunities of citizens of the United States. And if you are forbidding children from going to the schools that are next to their house, which endangers them to walk down the street, that is racist. He agrees.
On May 14, 1954, he delivered the opinion of the court, stating that, "We conclude that in the field of public education, the doctrine of separate but equal has no place. Separate educational facilities are inherently unequal."
I, Earl Warren, and the rest of the Supreme Court have decided that segregation in the public schools is a direct infringement on the 14th Amendment rights.
Expecting opposition to its ruling, especially in the southern states, the Supreme Court did not immediately try to give direction for the implementation of its ruling. Rather, it asked the Attorney Generals of all states with laws permitting segregation in their public schools to submit plans for how to proceed with desegregation. 65 years after the landmark Brown v. Board of Education decision that found racial segregation in schools unconstitutional, families and education advocates are still suing to compel states to uphold their education funding obligations. Plaintiffs in several subsequent court cases have argued that Kansas's education system violates the state constitution. In 2014, a district court declared that funding cuts unconstitutional and determined that insufficient state education funding correlated with failing test scores for economically disadvantaged students and students of color.
Yeah, I feel the same way.
Dog, hold my earrings.
Go on the opposition block, just like a lake. Go.